Yeah, and from connecting, I'm assuming with Mr. Lundy, but while we're waiting for that, through Mr. O'Neill, if you come over to the podium, please, sir. We'll go on the record in People versus O'Neill. This is file number 246759. The record reflects Mr. O'Neill is present here in the courtroom today. Mr. Trush, we have this set for a probation violation hearing today. Is that correct?
That's correct. And he would be admitting the violation for violating state law. So that would be count one, the non-technical violation. Count two would be dismissed. I had an opportunity to talk to Mr. Bernicow, and he had indicated to me his recommendation was going to be to discharge him from probation and defer to the sentencing in Wexford County.
Okay.
Which I think from talking to Mr. O'Neill is set to happen in about a week.
Okay. Ms. Davis, is that your understanding?
Yes, Your Honor.
Okay. Mr. O'Neill, have you had a chance to talk to Mr. Trush about this plea today?
I have, Your Honor.
Is that how you wanted to proceed?
Yes, it is.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. Mr. O'Neill, you understand that you do have the right to have a hearing as to whether or not you violated your probation?
Guilty as charged.
And I get that, but I need to go through your rights.
By all means, yes.
Yeah, okay. And so by the same token, you understand that by admitting you're guilty, you're going to be giving up that right.
Yes, Your Honor.
And although we've discussed what your sentence would likely be, nonetheless, the guilty plea here could nonetheless expose you to the maximum possible penalty on your underlying charge, which is up to 4 years. Do you understand that?
Your Honor.
With all of those things in mind, what is your plea to the violation today?
I'm guilty, Your Honor.
Has anybody threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anybody promised you anything other than what we've said here in court today?
No, Your Honor.
Is it your own free choice to enter this plea?
Yes, Your Honor.
Are you pleading guilty because you did violate your probation?
Yes.
All right. On or about September 27th of 2025, were you on probation here in Otsego County?
Yes, Your Honor.
Were you aware that one of the conditions of your probation was that you were to not violate any provisions of state law?
Yes, Your Honor.
And on or about that date, did you violate state law by being in possession of cocaine?
Yes, sir.
Thank you. The court finds the plea is knowing, voluntary, and accurate. The court is satisfied there's a factual basis to support a finding that you did violate your probation as alleged at count one. The court will accept your guilty plea. In terms of sentencing, Ms. Davis, was there anything that you wanted to add today?
Just an unsuccessful termination from probation, and then any fines and costs for being owed.
Mr. Trush?
I was just gonna say, all court fines are paid.
Okay.
Your Honor, I think that's an appropriate recommendation here. The court may recall from the original sentencing, Mr. O'Neill had kind of indicated he has some health issues, and that has caused him to self-medicate. This is a circumstance where he got some bad health news, and that sort of triggered a relapse for him. He's been in the jail since this happened in Wexford County. He's been engaged there. He does therapy twice a week.
I do CBT training on Wednesdays and I do DVT on Thursdays. I've been done completion of 2 of those programs, and I keep going. Nonetheless, I keep going through AA, even though I've been drinking for 2 years. I just believe in the program. Fortunately, I've learned that my leukemia metastasized in my spine, and I kind of lost it for a minute.
So I think the recommendation is appropriate to that context.
Okay, Mr. O'Neill, prior to the hearing today, I did have a chance to go through the file and familiarize myself with your case based on what you've had to say and counsel here today. I do think the recommendation's appropriate given the circumstances. I find that, and just for the record, I find that a updated PSI isn't necessary based on the court's intention not to impose any additional jail time. But in terms of your circumstances, number one, I'm sorry to hear about your health condition. That's tough news for anybody to get. And I think it's certainly understandable that you would react in the way that you did. I hope that some of the classes that you're getting and things you're working on will help you react in a more constructive way that would be helpful to your health as opposed to hurting it even more. So I hope that you follow through with that, and I certainly hope that your health condition, to
Yeah,
the extent it can improve, does.
I started SSRIs to help with the aptitude of the issue, and then I've started talking with Catholic Grace over there at Catholic Human Services about my time that I still have filling out programs so that we're actually getting. I'm going to be doing peer support until then, so I'm going to be getting certified through that until then. So
Good, good. Well, all those are positive things. They're going to be helpful in that. So yeah, I hope you do follow through and stick with those things. In terms of this case, I think that discharge is an appropriate resolution. So the court is going to follow that recommendation and discharge you unsuccessfully from your probation in this case. To the extent that there are any outstanding fines and costs, those will be preserved. If they're all paid, then they're all paid. There's nothing else to worry about with that. You do have the ability to seek an appeal of the sentence. Mr. Trush is going to provide you with an acknowledgement of your appellate rights that explain to you what those are. Ms. Davis, is there any jail credit showing?
Your Honor, what I have was sentences that you sentenced him to 9 months jail, held in abeyance, and he had credit for 37 days served.
So do you know how long Mr. Trush has he been accruing any credit on this file since he's been incarcerated?
yes,
He's been incarcerated since September 27th.
yeah. So we've done 97 days, 98 days, and then good time another 15.
Well, I don't count good time. I just count the number of days.
But yeah, so 107 then. 97, sorry.
97.
Is this one of those? Warrant was issued on 10/1. Were you in custody on October 1st?
Yes.
Okay. So credit from October 1st until today, right, Mr. Trush? Is that correct? 102 days plus that 37.
Plus the 37.
So the court will sentence you to 139 days with 139 days credit. Just needs to go in the judgment sentence.
Okay.
Our payments options, gotcha. Yeah, those ones.
Are you still under sentence in Wexford?
I am until Monday when I get sentencing.
Okay. Thank you. That's all for today. Good luck to you going forward, Mr. O'Neill.
Thank you, Mr. Mertz.
Still waiting for Antrim to, oh, here we go. Hey, sir, can you tell me your name there at Antrim County?
Kristen Lundy.
Lundy, okay. We'll go on the record in People versus Lundy. This is file number 236668. The record should reflect Mr. Lundy's appearing today by video from Antrim County Jail. I believe this is set for arraignment on a probation violation. Mr. Lundy had sent notification to the court that he was lodged there in Antrim. And so we set this for hearing today. Mr. Trush, just before I go through Mr. Lundy's rights with him, have you had a chance to speak with him?
So I have not had an opportunity to speak with him directly about this. He contacted my office actually before he was lodged in Antrim and explained to me what was going on. I've been in contact with Mr. DeLeo about it as well. But given the circumstances, it didn't seem necessarily appropriate for me to contact him when we're in that stage where I was his attorney, but I'm not appointed on the violation yet. So I am familiar with what's going on here for today's purposes. We would ask the court to enter a not guilty plea on his behalf. We would waive a formal reading of the allegations. And I would indicate he's going to qualify for counsel. I suspect I'll be appointed, but obviously I'm not the person who makes that determination. And I would ask the court to put a small cash bond in place so that he is earning credit for any time that he's spending there potentially.
Okay, Mr. Lundy, were you able to hear all of that?
Yes, Your Honor.
Do you disagree with any of the things that Mr. Trush had to say in terms of how you wanted to move forward with your case today?
No, Your Honor.
Okay, so the court will enter a not guilty plea on behalf of Mr. Lundy with regard to all the alleged probation violations in this case. The court will set this for a hearing. In terms of that hearing, Mr. Trush, is this something that he's lodged in Antrim as a result of the alleged SORA violation, or?
Yes.
Okay.
I would suggest to the court probably 60 days down the road to come back. I think that will give me an opportunity to have all the conversations I need to have with Mr. Lundy. It'll also give Antrim time to figure out, to work through their case. On the vast majority of these, and again, I talked to Mr. DeLeo briefly about it, but generally the practice is to defer to what's happening over there and then determine what we're going to do with the violation here.
Okay. Ms. Davis, in terms of bond,
We're in agreement with a cashier.
okay. And Mr. Trush has indicated he's requesting a low cash bond. Do you have any objection to that?
No, Your Honor. Agent DeLeo said that Mr. Lundy is not going to post the Antrim county bond presently, so he was in agreement.
Do you have any objection to the time frame on the hearing?
No, Your Honor.
Okay, so the court will set this for a hearing in about 60 days on the probation violation. The court will set bond in the amount of $1,000 cash or surety. And proceed with that hearing in about 60 days. Mr. Trush, anything further on this file?
Yeah, Tristan, do you have an attorney over in Antrim County?
Yes, Your Honor. Yes, sir.
What's your attorney's name over there?
Matt Conley.
Do I have your permission to reach out to him so that we make sure, the left and right hand both know what each other's doing?
Yes, sir. I had talked to him before, and I told him to get a hold of you to talk to him about the stipulations of what's going on here. So you're informed with the loop that's going on.
Okay, perfect. I will make sure that I get in touch with him, and I'll be in touch with you over there at the jail. All right?
Yes, sir.
Nothing further.
Okay, thank you. Mr. Lundy, that's all we have for today. The court's going to disconnect this time.
Yes, sir.
Thank you.
Thank you. Cause I know that got 10,000 down and 10% on here.
You, no, you, man.
We'll go on the record in People versus LaRock. This is file number 256930. The record reflects Mr. LaRock's present here in the courtroom today. Let's have counsel put your appearances on.
In a rubber appearing on behalf of people.
Thank you, Honor Registration Hearing on behalf of Mr. LaRock.
This is set for a status conference today. Mr. Trush, can you tell me where we're at with this file?
Yes, Your Honor. I do believe that we have a deal that we're going to enter into today. And I apologize that we were a little bit tardy getting back to the court here. Mr. LaRock, we had some issues to work through in regards to community corrections. So I wanted to make sure we had that squared up to correct that issue and address it. But we do have an agreement that we intend to enter into today whereby he will be pleading to an added count 2. That would be possession of a narcotic less than 50 grams, I believe. And that is the 4-year offense.
Okay. It's less than 25 grams. That's correct.
I had a 50% chance of getting it right.
Okay. And are we taking the factual basis to the methamphetamine?
Yes, and I will assist with the factual basis the court will allow.
Okay. Ms. Bruker, is that a correct statement of the plea offer?
Yes, Your Honor.
Mr. LaRock, have you had an adequate opportunity to speak with Mr. Trush about this plea agreement?
Yes,
Is that how you wanted to proceed today?
yes,
Can you raise your right hand, please? You solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
yes.
Thank you. Lower your hand. Mr. LaRock, are you currently on any kind of probation or parole?
Not that I know of, you know.
You would know.
You know,
If you were on probation
Yeah.
somewhere, you would know. So you're not on probation.
oh, okay.
He did indicate to me, I think he has a ticket that he picked up in another county.
Oh,
So
Yeah,
I
that
think
was
that's
before this, though.
you're not aware of any other.
I'm not aware of any other probation out there.
All right. So Mr. LaRock, what that means is that by pleading guilty to this charge of possession of a narcotic, the maximum possible penalty you can face would be up to 4 years and or a $5,000 fine. Do you understand that?
Yes,
Okay. With that penalty in mind, what is your plea to that charge today?
he's guilty.
Do you have questions for Mr. Trush about that? Or
I just want to make sure I go along with what we talked about.
Well,
Yeah.
if you want to take advantage of the deal.
Yeah.
okay.
I'm taking-
All right. So you're going to plead guilty today.
Yeah,
Okay. I'm gonna go through all of your rights with you, okay? So right now you have the right to have a trial. You have the right to have a jury trial. You have the right to have the prosecutor prove beyond a reasonable doubt that you're guilty. You have the right to have any witnesses against you appear at a trial and to have them testify at that trial. You have the right to have any witnesses on your behalf appear at a trial. You have the right to be presumed innocent at that trial. You have the right to testify yourself if you wanted at that trial. And you also have the right to remain silent and to not have that silence used against you at that trial. Do you understand all of those rights?
yeah, kind of, as much as I can.
Do you have any questions about all of those rights?
No, I'd have to study. I'm sorry.
Sure, that's all right.
Not used to this.
That's okay. That's why I want to make sure that you understand everything that's happening today. Because it's important that you know exactly what's going on, because it all affects your rights in your life. So if you do have any questions, I want you to feel free to stop me at any time and say, hey, I'm not sure. Can you explain this
I
more?
appreciate that, but I'm afraid not. Think of any.
Okay, all right. So the other thing that's important with regard to all those rights is that you know that by pleading guilty, you're going to be giving up all of those rights. You don't have
Yeah.
any of them anymore.
Yeah,
You
I
understand?
understand that.
Also, if you wanted to appeal this plea that you're making here today, in other words, if you wanted to try and get it reversed later, you would have to ask for the next higher court up, which is called the Court of Appeals. You have to ask for them to hear your case And they could say no, and then that would be it. You'd be stuck with what happened here today. Do you
Okay.
understand that?
Yes,
Has anybody threatened you with anything to get you to plead guilty?
no,
Has anybody promised you anything other than what we've talked about here in court today?
no,
Is it your own free choice to enter this plea today?
yes,
Are you pleading guilty to this charge because you are actually guilty?
yes.
Okay, Mr. Trush, if you'd like to, Mr. Trush is going to ask you some questions about what happened.
So,
Thank you.
Mr. LaRock, on October 20th of 2025, were you here in Otsego County?
Yes,
And on that date, was there a pipe inside your vehicle?
yes,
And on that date, did you know that there was methamphetamine residue in the pipe?
I thought it was,
But
you know, I thought it was just,
now today, though, do you know that there was residue inside that pipe?
yes,
And do you have any reason to dispute the test that it was methamphetamine?
no,
And you have no lawful authority to possess methamphetamine?
no,
I think there's a fact for this.
Mr. Rucker?
I agree, Your Honor.
Okay. Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
No, Your Honor.
Are you both satisfied that the court has complied with statute and court rule in taking of this plea?
Yes, Your Honor.
Yeah, sure.
Okay, Mr. LaRock, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there's a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We're going to set this matter for a sentencing hearing in about a month. You'll be given notice of the date and time of that hearing. It's important that you stay in touch with Mr. Trush between now and then, so that you're ready to go forward on that day. Also, before you leave today, you're going to meet with Ms. Davis to set up a time for a pre-sentence interview. Okay.
yes.
All right, Mr. Trush, anything further today?
No.
Ms. Rucker?
No, Your Honor.
Thank you, Mr. LaRock. That's all.
Thank you. Have a good day.
Were you ready on Mr. Barshaw's case? Mr. Trush?
Yeah, sure.
Barshaw, if you'd like to come forward to the podium, please. Court calls People versus Andrew Barshaw. This is file number 256830. The record should reflect that Mr. Barshaw is present here in the courtroom today. This is the date and time set for a sentencing hearing. If I could have both counsel put your appearance.
Your broker appearing on behalf of people?
Thank you, Your Honor. On behalf of Mr. Barshaw.
Mr. Barshaw, did you have an adequate opportunity to go through the pre-sentence report and talk to Mr. Trush about that?
Yeah.
Did you need more time to do that before we go forward today?
No, sir.
Okay. Mr. Trush, are there any additions, deletions, or corrections to that report?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Ms. Bruker, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocation?
Just briefly, Your Honor, NDOC is recommending 10 to 23 months in count 1 and 2 to 17 months for count 2. The facts leading to this case where the defendant was being surveilled by SANE. At the time of his arrest, he had around 15 grams of methamphetamine, 19 Ritalin pills, 3 syringes of methamphetamine, and Suboxone in his possession. He had 11 active warrants. He had a police scanner in his possession in an attempt to circumvent his arrest on these warrants. His prior criminal history, including some of the active warrants he had out for filing information involving methamphetamine. He's had controlled substance charges dating back to 2007. He served jail sentences before. He's been placed on probation before, and frankly, he's not benefited from either of those. So I would ask the court to consider for count 1 to issue an NDOC sentence. And that's really all I have, Judge.
Mr. Trush?
Your Honor, in terms of the prosecutor's recommended here, I don't think that's the appropriate response here. The court may recall Your Honor presided over the matter in Crawford County. The court may recall approximately a year ago, he was sentenced on the probation violation in Crawford County that stemmed from these charges. We stood before Your Honor at that time, and Mr. Barshaw told you, right? I need to make changes, right? And he's going to talk more about what happened in his life, but he had some life changes that were happening then. And he asked you to allow him to go into treatment, said, look, I need to make changes in my life. I'm done with this. I am ready to be done. I'm ready to make changes. At that time, Your Honor sentenced him to 9 months in the county jail. He had some credit. He had served the remainder of that time. Since that time, what Mr. Barshaw has done, I think, is show the court that he was serious about what he said then. Since that time, he has not had any additional charges or interactions with law enforcement. He's complied with the conditions of his pretrial release, and he's done the things that he's supposed to do. Again, since that time, he's made the changes that he told you a year ago he was ready to make and was going to make. I would suggest to the court and ask the court to consider his prior history is relatively small. Again, prior record includes 1 prior felony, 4 prior misdemeanors. It's relatively small. I would suggest to the court an appropriate response here is to give him an opportunity to show the court he is serious. I think he has shown in the last year since this started that he's serious about making changes. I would ask the court to craft a sentence that allows him to continue that. The court could impose a county jail sentence and make him eligible for work camp. That would ensure that he's being tested. And it would also ensure that he's able to maintain employment and be a productive member of the community. And quite frankly, I mean, his testing requirements through the work camp are more significant than they would be in any other setting. And certainly more than it's going to be in MDOC. And, you know, we say MDOC is for sobriety, but I think we all know that there are drugs in MDOC. Even if he were on probation here or on parole after that, his testing requirements through the work camp are going to be more significant than they would be in any of those circumstances. And frankly, I think that is good for Mr. Barshaw. The accountability there would be good for him. Prior to this circumstance, he had a child and realized he needed to make changes in his life. And he's done that. Again, since this incident, there's nothing to suggest that he has not done what he's supposed to, which I think shows he's a good candidate for supervision. And I think it would be a more appropriate sentence to have him in the county jail than an MDOC. If the court were inclined to do MDOC, I would ask the court to consider the boot camp program. Thank you.
All right, thank you, Mr. Barshaw. Anything you wanted to say?
I couldn't have put too much into better words than he could. Sorry, I lost my voice. I have a 1-year-old son at home. And when I did stand before you and tell you I need to make changes, I had just learned that he was mine. Just met him actually through visitation at the jail, as sad as that is. But since then, when I said I want to change, I meant it. This time I went through all the testing, everything that you guys sent me. Does my bond release conditions, and started a business. I've got a family. I talked with my mom again. I actually forgot a 9-month recovery coin that I was absolutely just willing to walk through the metal detector with this morning, just to show you. I worked hard for that coin. And I got my son and his 2 brothers at home. They're not mine yet, adopted wise. But everything in my life has changed. I need this whole entire old chapter just gone. And to work forward on that, I'm asking to let me just work forward on that.
All right. I did read through the report, so I'm familiar with what happened in this particular case. As Mr. Trush indicated, you know, I was already familiar with you and your circumstances generally from the Crawford County case. But I also read through that portion of this report as well, in terms of any updates from the last time you reported Crawford County. And, you know, there's a really wide range of options that the court has in this case because of the circumstances. One of the charges has an upward or top end guidelines of 23 months, so almost up to 2 years in prison. Because of the circumstances here, the court has the discretion to sentence consecutive. So if the court were to go to the top of the guidelines on both charges, you're looking at, you know, over 3 years in prison. Bottom end, of course, is basically 2 months in the county jail. So there's a huge range here of potential sentences. So I say that because number one, I want you to understand that you could be looking at a really lengthy prison sentence as a result of this. And you need to understand that that's where you're at in terms of your criminal history and where you're going to be if you don't get a hold of this and if you continue to reoffend. The next court that sees you is likely not going to have that lower end option anymore. And it's going to be prison time, no question. Do not pass go, you're going right to prison. With a young child and somebody in your circumstances, I don't think that's what you want to have happen. So I'm saying all of that because I want you to understand that this is really your absolute last opportunity to avoid that. And really, it could happen here in this case. So that's how close you are to that as your future in the short term. The circumstances here, 15 grams of methamphetamine is not a small amount of methamphetamine. The fact that you were absconding, evading law enforcement, all of those are aggravating factors, which would make, I think, the court more than justified in sentencing you to prison on this charge. This charge is here today. I also, though, have to recognize the mitigating factors, not just the aggravating factors. And those have been pointed out by Mr. Trush, I think, very well. In this case, what I think is an appropriate sentence is somewhere in the middle of that, because I think those things balance themselves out. I don't think, you know, at this point in your criminal history, you've had a couple jail sentences, you've had a couple chances on probation, but certainly not, I think, to the point where prison is absolutely the only option. Again, I think after this, that's probably where you're at. So balancing all the factors, the court finds that a jail sanction is an appropriate sanction, a sanction within the middle of the guidelines. And this is generally within the middle of the guidelines as to both charges. This is a nonviolent offense, so I think work camp is appropriate if you're eligible for that. So I find that an appropriate sentence in this case would be, as to both counts, would be 12 months in the Otsego County Jail. You have credit for 3 days served. The court, again, has no objection to your participation in the work camp program if you're eligible. Court is going to order a crime victims assessment of $130, court costs of $325, attorney fees of $350, and $136 state costs. You do have the ability to seek an appeal of this sentence. Mr. Trush is going to provide you with an acknowledgement of your appellate rights. Those papers will explain to you how to request an appeal as well as how to ask for a court-appointed lawyer to help you with that. Our child are remanded to the custody of the county at this time. Mr. Dick, were you ready with Ms. Price's case?
I would need about 2 seconds, Your Honor. My apologies, I just was speaking with the other one that's up. Tim.
Mr. Truce, have you seen Mr. Fick?
I have not.
Did you call a case?
What's that?
Did you call a case?
Yes, Your Honor, we are ready.
Ms. Price. Those people versus Carly Price, file number 256934. Record should reflect Ms. Price is present here in the courtroom today. I'd like to have counsel put your appearances on.
James Dick on behalf of Ms. Price, Your Honor.
This is set for a status conference today. Mr. Dick, can you tell me where this case is at from your standpoint?
Yes, Your Honor. So this is one of 2 matters that's up before the circuit court. She has another hearing coming up. I believe it's the 20th.
Is that before me?
Yes.
Okay.
And that is part of the reason I'm going to ask for adjournment. Other reason is I'm requesting an adjournment here to further plea negotiations and putting something together as a proposal on Ms. Price's behalf to see if we can reach a resolution in that manner. So I don't know if the court would be willing to adjourn it to the 20th to run the cases together so that they can be resolved together as well.
I mean, will we be ready to do something on the 20th?
Possibly. If we could get a little bit longer, I can make sure that everything is done beforehand for both files.
We set both for hearing in February, and I move the other one from the 20th to the February motion day. Can we be ready at that time?
Yes, Your Honor.
Okay. Yes. All right, so I'm going to adjourn this file today to the February motion day. I will also ask Jennifer to move her other file from the 20th to that February motion day and have them both same time. And at that time, so between now and then, council, I'll need you to have come to whatever agreements there are. Ms. Price, I'll need you to have discussed that with Mr. Dick and be ready for a final decision on that February day. Okay. All right. Ms. Bruker, anything further from your side on this file today?
No, Your Honor.
Mr. Dick?
No, Your Honor. Thank you.
Ms. Price, do you have any questions?
No, Your Honor.
Thank you. That's all for today.
Thank you.
Yes, Your Honor.
I see Mr. Fix. Court calls Zachary Fick, file number 256938. I could have counsel put your appearances on.
Dana Brooker appearing on behalf of the people.
Thank you, Your Honor. Richard Church, on behalf of Mr. Fick. Your Honor, I was able to call him during the break. He had his time mixed up He thought the hearing was at 1:30. He's on his way here now. He said he's about a half hour away. Yeah, if the court's willing, I'm more than willing to wait for him to get here. So,
Okay. All right, if you can just notify Leanne once he's here and we'll call that case.
certainly.
Our next file is set for hearing at 10 a.m. So we'll take a short recess until then.
Rise.
Okay, we'll go on the record in People versus Scott Weber, file number 256941.
For the record, Your Honor, Mike Roll on behalf of the people.
Mr. Weber, if you come right to the podium there. You're Scott Weber, is that correct?
Yes.
Okay. Mr. Weber, you're here without counsel, is that correct?
Yes.
Okay. Did you wish to have an attorney? Did you wish to seek to have an attorney appointed for you?
No.
No? Okay. The district court judge may have gone through this with you, but I'm gonna go through it with you as well. First of all, you understand that you do have the right to have an attorney,
Yes.
and that if you couldn't afford one, one would be appointed for you at public expense.
Yes.
Okay. Have you ever represented yourself before in court?
No.
Okay. Do you have any experience working in the legal field or any education background in the legal field? No. Okay. So I just want to make sure that you understand there are some risks to you representing yourself. There are certain aspects of the law, procedural aspects, in other words, how to file things, how to argue things in court, what the rules of court are that you may not be fully aware of, even if you tried to research it on your own. There are a lot of issues with regard to the substance of the law. In other words, what effect on your life different aspects of this case could have, what the consequences are in terms of penalties if you're eventually found guilty, and arguments that you could make that could potentially have, you know, the charges reduced or dismissed. And that without that experience in education, you may not know those arguments to make. Do you understand that?
When I was in county, they said I made too much money to get a court appointed attorney,
Okay,
and I can't afford one with what I make right now. I
okay,
mean, I would have liked one, but they said I made too much money.
okay. So you went through the process with MIDC?
Yes.
Okay, and they got your financial information and they determined that you did not qualify for a court appointed attorney? Okay, all right. Okay, so, and I understand, you know, there's a difference between what the MIDC considers indigency, in other words, inability to pay, and what you might consider to be, you don't have enough money. And unfortunately, what the law views that as is you're essentially making a choice not to use whatever money you do have to put towards an attorney. So is that kind of where you're at with it? You would hire an attorney, or you would take a court appointed if qualified?
Yes.
Okay, understood. All right. With that being said, then going forward, Mr. Rolla, have there been any plea offers in this case?
Yes, Judge, and perhaps it might clarify things a bit for the record. There's an offer of having him plead under 7411, as it's been explained to Mr. Weber. Should the court agree with that, and this is for possession of analogs, methadone pills, that after he successfully completes those conditions, then he would not, this would not be resulting in a long-term conviction for him on his record.
Okay, so the offer is as charged with 7411?
Correct, Your Honor.
Okay. Mr. Weber, you have the option, obviously, of accepting that plea agreement and pleading guilty, or you have the option of requesting a jury trial. And do you know what you would like to do in this case?
I would like to accept the 7411.
Okay. All right. Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you. Lower your hand. Mr. Weber, have you ever been convicted of any kind of offense involving controlled substances?
No.
Have you ever been convicted of any kind of offense in the past?
Yes.
Okay. How recently?
When I was 19, and it was burglary.
Okay. Was that here in Otsego County?
No, South Dakota.
Okay. All right. And how old are you now?
33.
Oh. So that was over 10 years ago.
Yes.
Haven't been convicted in Michigan of anything since then.
Nope.
Oh. You understand that the maximum possible penalty for this charge would be up to 2 years and or a $2,000 fine. You understand that?
Yes.
And with that in mind, are you currently, you're not currently on any kind of probation or parole or anything? With that in mind, what is your plea to that charge then today?
Guilty.
So I'm going to go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at a trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it. You understand all those rights.
Yes.
And you understand that you're giving up and waiving those rights by pleading guilty.
Yes.
Do you have any questions about that part of it? Has anybody threatened you with anything to get
No.
you? Has anybody promised you anything other than what we said here in court?
No.
Your own free choice to enter this plea.
Yes.
Are you pleading guilty because you are actually guilty of this charge?
Yes.
The information I have indicates this happened on November 4th of 2025. Is that the correct time frame?
Yes.
On that date, were you here in Otsego County?
Yes.
While you were here in Otsego County, did you have possession of some methadone?
Yes.
Do you have any legal right to have that at that time?
No.
Well, are you satisfied with the factual basis?
Yes, Your Honor, thank you.
Mr. Villa, are you aware of any threats, promises, or inducements other than what we stated here in court today?
I am not.
Are you satisfied that the court has complied with court rule and statute in the taking of this plea?
Yes, Your Honor.
Mr. Weber, the court finds that your plea is knowing, voluntary, and accurate, or is satisfied that there's a factual basis to support a finding that you are guilty of this charge. Court will accept your guilty plea. We're going to set this matter for a sentencing hearing. You'll be notified of the date, time of that hearing. You're going to meet with Ms. Davis from the probation department before you leave today, and she's going to set up a pre-sentence interview for you. It's important that you cooperate with that process, okay?
Okay.
Did you get the notice for today's hearing okay in the mail?
Yes.
All right, so we'll send the notice of that next hearing to that same address.
Okay.
If you have any issues, please notify the court prior to that date, okay?
Okay.
Thank you.
Thank you.
Versus Turbergen, case number 256915.
Take on behalf of Mr. Durgan, Your Honor.
Thank you. This is the date and time set for sentencing in this matter, and Mr. All right, can I have Mr. Turbergen, have you had an opportunity to go through the pre-sentence report and talk to Mr. Dick about that? Mr. Dick, are there any additions, deletions, or corrections to that report?
Your Honor, the only, well, the addition that we would request is CFJ 284, page 11, under treatment. Yes, Mr. Trubruggen has generally been in some sort of treatment since he was 6 years old. The specifics of it, I do not have, so I think that it would be better to just note that he has been in treatment for the majority of his life.
Well, I think maybe under treatment, what I would do is just have put in a sentence saying see below, because it does kind of after that go into the details of this treatment. Is that acceptable?
Yes.
Okay.
Yes, it is here.
Any other changes?
The only other thing I think that there was a statement of a suspected gang association. We would request that it be removed from the PSI. However, we also understand that that's not to us necessarily. So
Mr. Rolla,
I'm sorry, Judge?
do you take any position on the request to remove the, there's a sentence in here indicating that there was.
People take no position.
Ms. Davis,
Yes, Jen.
sorry, I know you're doing multiple things here. We're going through Mr. Terbergen's PSI. There's been a request to strike the information under the gang involvement narrative. Can you just state for the record where that information came from?
That was taken directly out of our Michigan Department of Corrections records. Your Honor.
Okay, so that's something that's already in.
It was
DOC.
reported in prison.
Since that's already part of the DOC records, Mr. Dick, the court's gonna deny that request to strike. So that'll remain in there.
I figured that. Thank you.
Okay. Any challenges to the scoring of the guidelines?
No, Your Honor, there's not.
Mr. Rowland, do the people have any additions, deletions, or corrections?
No, Your Honor, thank you.
Any challenges to the scoring?
We do not.
Do the people have any victims that wish to address the court today?
We do not.
Anything on behalf of the people for allocation?
Just very briefly, Judge, just a situation where the defendant at the time of the offense used his employment situation at Speedway gas station to commit thefts of their customers. In this case, the victim in this matter, Ms. Willard. I think the court has to take that into consideration in regards to imposing a sentence. I think it sends a very bad message in regards to persons coming to Otsego County to be here, that they can't be afraid of being able to just go in and gas and then having their credit cards used and stolen by other persons employed here. Thank you.
Thank you. Mr. Dick, anything on behalf of Mr. Tipperian?
Yes, Your Honor. Mr. Terbergen, he has been dealing with a lifetime of mental health issues, starting when he was 6 years old. He first was placed on medication at about 7 years old. He was in counseling for mental health from 6 years old until, well, he's presently again. However, he did have a period where he was incarcerated in prison from in 2019, where there was a rather significant break in his treatment therapy. He's been diagnosed with many different things. Some of them being like schizo disorders. Some other ones that are already in the PSI, and that have been noted in there. But it's something that's been ongoing. I did speak with his mother, and she did tell me that Mr. Terbergen was always a happy child, even though he had some underlying mental health concerns. He was always helping people, helping others. He was ambitious. He was a hard worker. Is a hard worker. He started a lawn care company at 9 years old. Had 40 clients by the age of 15. He's done a lot of things that, well, you would expect of normal people. He's lived pretty well for the most part. However, there was always the underlying mental health issues that caused him some problems. When he started getting into trouble, he didn't really have a good reason himself why he did whatever he did. Even in this instance, Mr. Terbergen doesn't have a reason why he took the money from somebody else's account and put it on these gift cards. This is something that he's had plenty of time to think about and consider. He did spend 100 days in the Otsego County Jail on a parole hold. And you know that was one of the biggest things burning him that he was contemplating. But to this point in time, Your Honor, it's still not figured out why. So with that, I did have a conversation with a couple of people, Mr. and Mrs. Sirac from who are members of the Free Church, and they have been essentially his church family since he was in about the 9th grade. They believe that he has always been a nice person, a nice young man. He's tried to do things to be accepted by people, and they believe that he continues to do so. So he started their youth group when Mr. Sirac was the youth pastor back in 9th grade. He's been in their Bible study since, goes over to their home. They feel comfortable with him being in their home. He did, once he went to jail or prison, he did have a break in his involvement with the church or attending church or being part of the Bible study. However, when he was released, it resumed. And likewise, after this parole hold that he just had, it resumed. Mr. Sirac, he did make a statement to me that he felt that Mr. Chabrugan, he called him JT, just to kind of highlight their relationship. And he feels like he was perhaps let down by not getting the services he needed for his mental health issues. They were apparent that there were, it was apparent that there were mental health issues. However, in speaking with Mr. Chabrugan and his mother, it seems that they did go to rather extensive lengths trying to get him therapy, treatment, and other things. But I guess in part, things were somewhat limited by funds. They did attend a Amen clinic in Virginia, which had to be paid for. That was a very expensive ordeal, but it was to diagnose and further assist the local mental health professionals in figuring out what was going on with them. They did come back with a couple different things, ultimately a type of developmental disorder and a pervasive developmental disorder, and then a couple other things that sort of helped his doctors here, but he was having trouble getting into appointments with them. So ultimately, in prison in 2019, he was diagnosed with the schizoaffective disorder. However, he was not treated for it. With that in mind, Your Honor, we are asking that the court consider that Mr. Chabrugan generally seems to be a good person. The guidelines, we would ask that since the court is required to sentence him consecutively, we would ask the court to consider perhaps some manner of leniency in assessing his sentence within those guidelines, just with the knowledge that he has many mental health issues that need to be addressed. I anticipate that few of them will be addressed in prison, just because of the resources and past experience. I have nothing else here. So thank you.
Thank you, Mr. Terbergen. Anything you wanted to say today?
Only that I regret what I did, even though I don't know really why I did it.
So Mr. Terbergen, I did read through the report. So I'm familiar with what you did in this case to cause you to come before the court, using somebody else's credit card or debit card to make purchases for things for yourself. Sounds like the facts here that person either lost or left their card, at the gas station. It was put in the lost and found, and then were working there and used that access in order to use that card for your own benefits. And you did that while you were on parole, which of course causes even more complications for you. I'm also aware of your background and history based on the information contained within that report. I think it's certainly well established, as your attorney has indicated, that you do have some diagnosed and legitimate mental health issues that I have no doubt contribute to kind of some of the things that you've done to get yourself into trouble throughout your life, which has been extensive, and you engaged in some pretty serious and dangerous conduct during your time, and spent time in Department of Corrections. You've been on probation. You've had some time in jail. All of those things have been attempted throughout the years, in addition to what your family and friends have done in order to try and help you deal with those underlying mental health issues. And that's a difficult thing, when somebody engages in conduct because of underlying mental health issues that is criminal. It's a difficult problem, because where does, that mental health aspect of it end, and where does your responsibility to control your actions and not put other people at risk or harm other people come into play? And where does the court fall in terms of recognizing that something you can't help, which is your mental health condition, just like any other disease, people can't help when they're sick, it just happens to them. Where does the court, how far does the court take those things into consideration in terms of what you can't help, and then draw the line where there are things that you could help and not do, and exercise self-control? And that's a hard position for the court to be in, because I do recognize that a lot of this is based on things that are outside of your control. But at the same time, I have to recognize that in this case, as in some of your other cases, there is a victim here. There's somebody who suffered not just a financial loss, but there's a psychological effect to that person too when they're victimized. People feel stupid, people feel bad, feel insecure, unsafe going forward when somebody has done something like what you've done here. So I have to try and balance all of those things. And then, of course, from a legal standpoint, your past record factors into it, what the guidelines are and your parole status. And I have to recognize that as well. I'm bound to by the law. When I put all of those things together and looking at the guidelines, your conduct in this case, your past conduct, and the fact that various attempts at treatment, various penalties prior by the court haven't been able to correct what's been going on, the court finds that an appropriate sentence, and one that is within the guidelines, is a Department of Corrections sanction. And that is a sanction of 18 months to 6 years. And that's as to both charges. Because of your parole status, you do have credit for 0 days served, and that sentence is required to be served consecutive to any parole sanction, which I understand in this case you've already served. But nonetheless, the court has to note that for the record. Court is going to order that you pay restitution in the amount of $784.70. That's payable to the Otsego County Clerk to be dispersed to the victim in this case. Crime victim's assessment of $130, court costs of $325, attorney fees of $350, and $136 state costs. You do have the ability to seek an appeal of this sentence, and Mr. Dick, you could provide those papers to Mr. Terbergen. William, are you ready? Mr. Terbergen?
That file, I don't know if I'm.
People versus Antoine Shaw, file number 256927 and 6928. Record should reflect. Mr. Shaw, if you want to come up to the podium, please. Mr. Shaw is present here in the courtroom today. If I could have counsel put your appearances on.
Your Honor, for the record, my own.
Brian, good to have you on. Podium, am I right? Your status now.
Thank you. Mr. Clayton, can you tell me the status from the defense side of the trial?
Yes, Your Honor. I know this file is not an old file, it's actually newer to me. We were waiting on some digital media, part of our Brady disclosure from the prosecutor's office. We did receive some, but we're anticipating some more body cam and of that ilk. So I'd ask the court for additional time to exchange discovery so I can more thoroughly understand the case and advise my client likewise.
Okay, Mr. Rowland.
I don't have any objection, Judge. It's a situation where the case is not that old, and Mr. Clay has recently come into the matter. I believe that was second week of December, perhaps.
Yeah, that's fine.
And we're on only in the first week of January.
Okay, so Mr. Clayton, I want to build enough time for you to do what you need to do before the next appearance. So is 30 days enough for that? Do you want 60 days? I'd rather set it at a time where you'll be able to take some action at the next year.
Why don't we go the 60-day route? I'd just advise the court as we get to the 60-day, I'm planning to be out of the country from the end of February to the first week of March. So I'm only gone for about 12 days.
Okay, we could set it for mid-March.
That'd be fine, sir. I'll be back. I think I'm back to 6th.
Mr. Rolla, do you have any objection to that?
Not at all. I was aware of Mr. Clay's out of country experience.
All right, Mr. Shaw,
Yes.
you understand that this is going to result in a delay of how your case is processed?
Yes, sir.
And have you talked to Mr. Clayton about that?
Yes, I have.
Do you have any objection to setting this out to mid-March?
No, Your Honor.
So we'll set both files for hearing in mid-March. That will be the plea cutoff.
Yes, sir.
So, Mr. Shaw, between now and then, it's important that you stay in touch with Mr. Clayton, and that when we're back in court in the middle of March, that you're ready with a final decision as to whether you want to accept any plea agreements or whether you want to proceed to trial on these files. Okay.
Okay, sir.
All right. Thank you. That's all for today.
Thank you. Are you still on the record?
Yes.
Oh, I just was gonna say something about this.
Okay.
I'll tell you another time.
Okay. Sounds good. Thank you.
You're on Mr. Spinks here.
Okay, I got one other case I need to take prior to that. You guys can be seated because it's on TV. All right. Okay, we're gonna go on the record in People versus Eugene Demick, file number 256920. And counsel, if I could have you put your appearance on, please.
For the record, Your Honor, my call to people.
Good morning, Your Honor. Matthew Kolajewski on behalf of Mr. Demick.
Okay, and the record should reflect Mr. Demick is present today by Zoom video along with his counsel by prior approval of the court. This is set for a status conference today. Mr. Kolodziejski, can you tell me where things are at from your standpoint?
Judge, since we were last here about a month ago, Mr. Demick and I have sat down on multiple occasions and discussed the path forward in this matter for literally hours and hours on end. While they were productive discussions, it appears that there remain some significant issues that exist in the relationship to the extent that at this point, Mr. Demick is asking for new counsel. Specifically, he's asking the court for appointed counsel. I have been retained on this matter since the outset. However, he is a retired disabled veteran, and I believe that financially he would qualify for appointed counsel. So that's where we're at presently, Your Honor.
All right, Mr. Demick, is that correct? Do you wish to discharge Mr. Kolodziejski and request a court-appointed attorney?
Yes, Your Honor.
Okay, so the court is going to refer your case, Mr. Demick, to our local appointing authority. They're going to be reaching out to you to talk to you about your finances to make that determination as to whether you do qualify for court-appointed. It's important that you follow up with that communication and that you provide whatever information they're requesting. Do you understand that?
Yes, Your
Honor. Mr. Trush, I know you're not in charge of it, but I'm just trying to, for purposes of scheduling, if I were to set this for mid-January, do you think that's going to be enough time for MIDC office to reach out and make that determination?
I would think so. And I'm sorry, I didn't catch the name of the defendant.
Demick, D-E-M-I-C-K.
Mr. Demick, what's a good phone number for us to reach you at?
It's 734-216-3541.
I can provide that to Mr. Gibbs' office.
Okay, so Mr. Demick, the court is going to set this for another hearing in about 2 weeks. You'll be notified of the date and time of that hearing. We can do it by Zoom, just like we're doing today. Did you want to request that as well, like you did for today?
That's fine, Your Honor.
Okay, so we'll set it as a Zoom hearing, so you'll need to sign in just the same way that you have today for that hearing. And at that point, we'll have an answer as to whether you qualify. If you do qualify, then you'll have an attorney appointed for you, and we'll decide how to go forward with your case. If you don't qualify, then we're gonna need to move forward with your case one way or the other. So that means, you know, if you want to rehire Mr. Kolodziejski or you want to seek a different attorney on your own, then you'll be free to do that. But I just want you to understand that this delay of about 2 weeks is about all the court's going to allow in terms of delaying your case for you to obtain different counsel. All right.
Yes, Your Honor.
So you need to stay on top of that and stay vigilant. It's in your own best interest to have your rights protected by an attorney, whether that's an appointed one or one of your choice. But either way, that responsibility is on you, and the court's going to proceed with your case. So I just want to make sure you understand that, okay?
Yes, Your Honor.
All right, Mr. Kolodziejski, then based on what we've stated for the record here in Mr. Demick's statements, I don't think you need to file a motion to withdraw. I will approve that withdrawal based on Mr. Demick's statements here for the record, but I would ask that you prepare an order and submit that to the court so we have that for the file officially removing you as counsel.
I will do that, Your Honor. Thank you.
All right, and Mr. Roll, I know I've done all of this without any input from you because it's kind of Mr. Demick's thing, but any record that you wanted to make today?
Judge, no objection to the court doing that. I would indicate that there is a plea offer in the record for a plea to counts 1 and 2 for dismissal of counts 3, 4, and 5, and the payment of the $200 blood test fee, talking about a BAC of 0.209.
Okay.
Thank you, Your Honor.
All right, Mr. Demick, do you have any questions about how we're going to go forward from today?
No, Your Honor, I'll hopefully be able to speak with a new lawyer and go from there.
Okay, Mr. Kolajewski, anything further that you needed to state for the record today?
No, Your Honor, other than I'm happy to cooperate with successor counsel in providing discovery and getting them up to speed to the best of my ability.
Okay, very good. Thank you. All right, that concludes this hearing, and all parties on this case are free to disconnect. Okay, Mr. Weber, if you want to come forward to the podium, please.
Mr. Fink.
I'm sorry, Mr. Fick. We're on the record in People versus Fick, file number 256938. Mr. Fick, it goes without saying that it's important for you to be here in court at the time of your hearing. If you have questions about that, you can always talk to your lawyer. Mr. True should be happy to remind you of that. I just want to make you aware that if you fail to appear in a timely manner, the court can issue a bench warrant. Even if you show up later, have you taken into custody and remain in jail until the next day you get a hearing. So to the extent you don't want to sit in jail, I recommend that you do whatever you need to do to know when you need to be in court, okay? Mr. Trush, can you tell me the status of this file today?
Yes, Your Honor. We do have an agreement from the prosecutor that we intend to enter into today. And we will be asking the court to set the matter for sentencing out to the first week of March as opposed to February. Mr. Fick has a contract job that ends sort of the later part of February. And we anticipate at least some upfront jail here. So we'd like to let him have an opportunity to finish that. The deal contemplates playing to count 1 and 2 as a habitual second with the dismissal of counts 3 and the habitual 4.
How about the second or subsequent?
And the drug double as well, Judge.
Dismissed?
Yes, all enhancements, all other enhancements except for half 2.
Okay. Any other clarifications, Mr. Rolla, on the terms of the agreement?
No, Judge.
Mr. Fick, have you had an adequate opportunity to speak with Mr. Trush about this plea agreement?
Yes, Your
Is that how you wanted to proceed today?
Yes, Your Honor.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. Mr. Fick, are you currently on any kind of probation or parole?
No, Your Honor.
You understand that by pleading guilty to count 1, which is possession of methamphetamine, as a second habitual offender, the maximum possible penalty that you could face would be up to 15 years. You understand that?
Yes, Your Honor.
And count 2, which is possession of alprazolam or Xanax, as a second habitual offender, again, that penalty, maximum possible penalty would be up to 3 years. Do you understand that?
Yes, Your Honor.
That in mind, what is your plea to each of those charges today?
Guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand all those rights.
Yes, sir.
And you understand that you're going to be giving up and waiving all of those rights by pleading guilty.
Yes.
Also, you don't have an automatic right to appeal the plea that you're going to be making here today. You can only do that by leave, and that means that you would have to ask for the Court of Appeals to hear your case. They could say no, and that would be the end of any appeal. You understand that?
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
Never.
Has anyone promised you anything other than what we said here in court today? Is it your own free choice to enter this plea?
Yes, Your Honor.
Are you pleading guilty because you are actually guilty of these charges?
Yes, Your Honor.
The information I have indicates that this happened back on June 2nd of 2025. Is that the correct time frame?
Yes.
On that date, were you present here in Otsego County?
Yes, Your Honor.
While you were present here in Otsego County, did you have possession of some methamphetamine?
Yes, Your Honor.
Did you know that that's what that was?
Yes.
Did you have any legal right to have any amount of it at that time?
No, Your Honor.
Also at that time, did you have possession of some alprazolam or Xanax?
Yes, Your Honor.
You know that that's what that substance was?
Yes, Your Honor.
Do you have any legal right to have any amount of that at that time?
No, Your Honor.
Had you been previously convicted of use of methamphetamine here in the 46th Circuit Court back in October of 2024?
Yes, Your Honor.
Mr. Rolla, are the people satisfied with the factual basis?
Yes, Judge.
Mr. Truce?
The only clarification or correction I would make, the court asked about an offense date of 6/2/2025. I think that's a typo. I'm looking through the affidavit and the police reports and they all say 6/28.
Okay. Mr. Fick, in terms of that discrepancy in the date, does that change anything about any of your other testimony in terms of your possession of those substances?
No, Your Honor.
All right,
Otherwise, I'm satisfied there's factual basis.
thank you. Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor. And again, that prior offense date apparently was October 9th, 2024.
Okay. Mr. Church.
I am aware of no threats, promises, or inducements.
Counsel, are you both satisfied that the court has complied with statute and court law to take on this, please?
No, Your Honor.
I'm satisfied.
Thank you. Did I miss something that you looked?
No, Judge.
No, Mr. Church did.
No, no, Your Honor. I don't believe you missed anything.
Okay.
Judge, did you place him under oath?
I believe I did. Did I place you under oath, Mr.?
Yes.
Yeah.
Okay, I'm sorry, I missed that.
That's right. So we're all here. That's why we all ask each other if we've all complied with statute and protocol and make sure everything gets covered. All right, Mr. Fick, the court finds that your plea is knowing, voluntary, and accurate, or dissatisfied that there's a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea as to full. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. It's important between now and then that you stay in touch with Mr. Trush so that you're ready to go forward on that date. Mr. Rolla, did you have any objection to the request to set sentencing in March?
No, Judge, not at all.
Okay,
Thank you.
so you can anticipate it'll be around the beginning of March, but again, make sure you stay in touch with Mr. Trush, okay?
Yes, sir.
Before you leave today, you're going to meet with Ms. Davis to set up a time for a pre-sentence interview, and it's important that you cooperate with and complete that process. Thank you.
I was for the appeals for seeking.
You ready on Mr. Barrett's?
Yes, I'm attorney Nathaniel Taylor. I was just gonna come check in so you know who I was.
All right. We'll go on the record in People versus Michael Baird. This is file number 2366001.
The record should reflect Mr. Baird is present here in the courtroom today. If I could have counsel put your appearances on.
Yes, Your Honor, for the record, Michael, on behalf of the people.
Attorney Nathaniel Taylor for Mr. Baird.
So this is set for probation violation hearing today. Mr. Taylor, it looks like we had adjourned this from December. Tell me how you intended to proceed today.
Well, after speaking to the probation officer, Mr. DeLeo, yesterday, it was my impression that while the case is pending in Allegan, he's been arraigned on it. It's set for a probable cause conference on the 15th and a preliminary exam on the 20th. Which is that not next week, I guess that's the week after. Well, part of next week, part of the week after. That we wanted or he was willing to wait until after the criminal case, which is not set for jury trial or anything, I understand. But because he's presumed innocent on that case, I would like to adjourn this until then. I'd sent a step up yesterday, but then wasn't able to get agreement from the prosecution on it. So here I am today.
Okay, Mr. Rolla or Ms. Davis?
Judge, in regards to the probation violation, while the people would agree, in fact, I discussed this in fact with counsel yesterday afternoon into the evening, that one of the counts, I think count 3, is controlling, if you will, in regards to its connection with the criminal charges pending down the Allegan County. Counts 1, 2, and 4 or not, we could proceed. As far as an adjournment, if the court's going to grant one, since we already had a 90-day adjournment and this matter is still in the district court. Apparently though, as of no actions of defense counsel, apparently there was a delay down in Allegan County for matters that are apparently out of his control, as least as I know it. So if the court's going to grant an adjournment, I would ask that it will be a short adjournment, 30 days at the most. Any more than that, unless we can get some information of definitive dates by Allegan County, we don't want this matter just remaining open for 3, 4, 5 months at a time.
All right, I mean, I guess my question is this, I mean, this isn't an unusual procedural standpoint where somebody's probation violation is based on allegations of underlying additional criminal conduct, and very frequently adjourn those things out 90 or more days even for the underlying charges to be resolved. So is there a reason why in this particular case you want to move forward with this?
Well, Judge,
different than we would in a typical case.
My apologies if I wasn't clear. It's not so much that we want to move forward immediately. We just want whatever date there's going to be something a little more specific. It is an unusual case in the light of the fact that the charges down in Allegan, as I understand it, after speaking to both the Berry County and Allegan County prosecutor's offices extensively yesterday morning, it was a special prosecutor case because one prosecutor had a conflict, and it took a very long time. And I guess opposing counsel might have a better idea than I would, about 3 months to get it to the district court, which is why there's the delay. If the court's going to set a date, let's set a definitive date, even if you've got to set it out 2 months or whatever, but just so we have something specific as opposed to this just laying out in limbo.
Sure. Okay. That
I hope that's clear.
Yes. Okay.
Thank you, Your Honor.
Procedurally, down south, a lot of prosecutors' offices wait until they have blood test results back to charge a case. This is kind of local practice, and then there's some other ones that will charge right away and then set an arraignment out 30 days or 45 days for some counties. It is a little frustrating too, because some of them just issue a warrant and then don't tell anybody about it. 45 days later. So it's not, I wasn't shocked. I mean, I was a little bit shocked by the fact that they went 90 days or whatever to charge it, but certainly in other counties, it's not uncommon for blood test cases to take 60 days. That area.
All right, what I'm going to do then, I'm going to set this for a probation violation hearing at 90 days. Mr. Rolla, if the underlying charges haven't been resolved one way or the other by that point, and you want to go forward with that hearing, then of course you'll need to have witnesses and everything ready.
Correct.
So that we can have an evidentiary hearing and the court can decide. if we get to 90 days and it hasn't been resolved yet, and the two of you agree to adjourn it until it is resolved and set it for another date, I don't have an objection to that either. So I'm gonna leave that to council, but I'm gonna set it for hearing in 90 days with the idea that this is either gonna be resolved by plea or by evidentiary hearing on that date, unless otherwise notified by council.
Would the court be willing to entertain a cops for today? If we,
I typically don't engage in sentence bargaining. That's not a practice that I view as helpful or appropriate. So I certainly, to the extent that there's some type of Killebrew agreement that I'm not bound by, I don't have any problem accepting a plea pursuant to a Killebrew and giving the defendant the right to withdraw if I don't agree with the sentence.
I just like to show you some of the stuff that he's done. And then if that would, if based on that, the court would be willing to just continue his probation at this point, or a short term of jail or something. I just to have some clearance on it, I guess.
You know, I think there's a lot going on with this case. And I think that I would need something in the way of an updated PSI if we were going to take a plea before I could make a decision about what I thought the appropriate way was to go forward. I have a lot of concerns about the underlying facts in this case and the new allegations of continued operating while intoxicated. That presents to me a very significant public safety.
I have an updated substance use assessment. He's been attending counseling, he's also been attending AA, which I don't have his most current AA sheet here.
That's all good, and I think that's all positive, and I certainly would take all of that into consideration, but I would need to hear the other side of this too.
And he's also been on a alcohol tether on his ankle since his arraignment on the 27th without any issues as far as.
I think that's probably very appropriate as well, so I mean, those are all positive things, I think. But again, I think I would need to get information from the prosecutor's side on this as well.
Judge, while we're on that topic, there's some confusion as to why this gentleman who was convicted back in 2024 and then got a furlough until April 1st of 2025 is still out and has not served any of the time of the 1-year sentence to court imposed.
Yeah, I mean, again, that's part.
Why isn't he in jail right now?
Well, that's part of why I have concerns about continued use of alcohol when he was released because of health issues, and apparently that's not stopping. So, again, that's why we need to have this set for hearing. That's why I don't want to make decisions about what's appropriate or not appropriate while we're on the fly. So I'm scheduling it the way it's scheduled. If council wants to come up with something else, I'm happy to consider that, but as of right now, we'll go forward in 90 days.
Can I address what was just said on the record?
And Judge, I understand that, but I'm talking about the original sentence that he was placed on probation. He still hasn't served that sentence.
You know, I don't know where all of that stands. I'm not going to get into it. You guys can argue about this off the record. It has nothing to do with why we're here today.
Very good, Judge.
That's an incorrect statement that he just made. He did serve 30 days jail starting April 1st of last year.
Yeah, I know. But I know there was a lot going on with health problems and wanting to get out and not have to serve more time.
But he did serve the 30 days at the court order starting April 1st until the 24th.
Yeah,
so
okay. I just want lots of back and forth with Mr. Barrett's prior counsel on all of those issues. And that's why one of the first things I said was there's a lot going on with this case that I need to know about before I make any decision about if he's found guilty, where we go from there. So, okay.
I just want to make sure we were aware that he had done the 30 days. So 90 days out.
Correct.
Can I contact my office to clear the date that we're picking?
I'm not gonna be able to give you a date here today from the bench.
Okay.
I'll send it out from my office. Okay, if you have problems, contact us.
Okay.
Okay.
If there's a problem, it's only have to be 1 or 2 days. Thank you.
Thank you. That concludes our hearing for this morning. And our morning docket. The court will be in recess until 1.